that are very important in our country, and we want to go through to outline a little bit about the president is wanting to push upon the country. And before we read this particular section, I'm going to drop down to a story that we shared last night in the PAG group. This story that we're going to read, this case that we found on LexisNexis. Before I read this story, let me go over to LexisNexis is a software, but anyway, this is where all the documents are gathered together about judicial court proceedings and judicial issues in our country. The thing that you have to be careful of when you read through this, if something doesn't sound right, then it's important to go back to the congressional records and match up what you're reading in Lexis or in the Vernon's Annotated or any of the law books, that what's written is what Congress had the intent to put out to the people. They are not above changing a little bit of the words and moving things around. And when they do that, we go back to our understanding of the Constitution, that you have a Senate and a House of Representatives that makes up Congress, and Congress will approve a bill that comes through the Senate or the House, comes into Congress, they send it over to the President, very high-level overview, he signs off on it, that becomes law. Obviously, in our system, with cases getting overturned and things that are unconstitutional, any law that's put out by Congress and the President, if it turns out at a later point in time that is found to be against the Constitution, then that law is null and void at its enactment, meaning that that law is no good. However, the problem that we're going to see tonight is that may take 20 years before you get to that point. Whenever we come across something that we're reading on LexisNexis or any of the law books, if there's something that just grabs inside of you that says, I don't remember that works that way in the Constitution. And that's why it's so important, even though it is very dry, to go through the Constitution and the Bill of Rights. It's very important that you get a real good, solid foundation of our Constitution and our Bill of Rights to know exactly what they can do and what they can't do. That way, when you spot something that's not right, immediately it should go off that, wait a minute, there's a problem here, and we need to go in and investigate this. And the only way to do that is to go back to the congressional records and find out what Congress had, what their intent was when they put that out there. LexisNexis puts these cases together, as you'll see in this particular document that we're going through today. Up here in the corner, it's 81 pages, and in order to get an understanding of really what's going on, it's important that you read the entire 81 pages. So needless to say, it takes a long time to be able to put together your research, and you may get to page 80 or you may get to page 56 and find out that's not the right document that you're looking for, and now you have to go and search someplace else. In this, when they put these things together, they will have an actual summary of what goes on in the particular case. Sometimes you can read through this summary and say, is that something that applies to me, or should I keep reading or not keep reading? Now, I have found in these summaries that once you get into the case, well, that summary might not have been written correctly, so you can't really take that at face value 100% of the time. But 9 times out of 10, it is correct. It can save you quite a bit of time. But this particular case was in the 1940s, and I'll show you what we're talking about a little bit later on. This is talking about Pearl Harbor, 1941, on Sunday, December 7th. 1941, the Japanese launched a sneak attack at Pearl Harbor that decimated the U.S. Pacific Fleet and forced the United States to enter World War II. However, it has come to light that President Roosevelt knew about the attacks before it happened. And some of you that have watched some of the films and have read some of the documents behind this, they moved a lot of warships over there in that area specifically to be able to do what they did. Although Roosevelt may have gotten more than he bargained for, he clearly let the attack on Pearl Harbor happen and even helped Japan by making sure the attack was a surprise. So let's go up to the front of our document. The government concluded that as long as the President could establish that an emergency threatened the safety of the nation, the President, under this aggregate power as Chief Executive and Commander-in-Chief, had the authority to seize the steel industry to ensure the uninterrupted supply of steel. Both historical events will be reviewed as case studies demonstrating how the judiciary both ratified and overruled Truman's overreach of presidential power in the face of assertions of national security necessity. Justice Jackson's opinion is well cited for the proposition that the President in time of war or national crisis is not commander-in-chief of the nation, and that the powers of the presidency, even during war and crisis, are not without boundaries, accepting the assertion that the early months of 1942 were militarily dangerous for the United States, and that invasion was more than an abstract possibility. So this is after Japan had attacked Pearl Harbor. The court concluded that reasonably prudent men charged with the responsibility of our national defense had ample grounds for concluding that they must face the danger of invasion, take measure against it, and in making the choice of measures, consider our internal situation cannot be doubted. 17 months later, submitting its brief in Hirabayashi, May 1943, defending the crew policy, the government returned to the court in October 1944, term to defend the exclusion policy in Korematsu, the authority of the removal of persons of Japanese ancestries has been determined by this court in Hirabayashi. Citing his decision, Schomer and Judge Gani concluded that although the exclusion order are within the war powers of Congress and the President. So when Obama comes out here and declares that he's going to take executive action or pass an executive order for the gun grab, he has to have Congress behind him in order to get this done. And he cannot act unilaterally to do this. Now, our nation, and a lot of you guys that have been following what's going on and past history, whenever they come in and take the guns, there's an absolute slaughter of the citizens and the people of that particular country. They have been planning this. They have designed this. There's documents that have been declassified since 1961 for them to be able to come in and take our guns. This is going to be a very, very hot issue coming forward. This standoff out there in the Northwest about the rancher and about the guys going into a national park. We discussed that last night in the Private Attorneys General class about jurisdiction and about if land has actually been given to the federal government, and if so, when, where, and how. And so we need to get off some PIRs and FOIA requests in order to kind of track that down. And that's going to take people. Our whole focus on our Wednesday night group and in our first hour is to give people a little bit of a glimpse of where we're going with the PAGs. And then in our second class, in the members only class, we get into some real details of what we're doing and what's going on. But we have to have people, and it's very important that we're able to reach out to our friends.